This is Dr. S. the Legend. He's back. I want to start talking about the Minnesota situation. Sort of wrap it up. Covered it in the last podcast. The first thing I want to talk about is the second incident in Minneapolis involved death of an individual who was carrying a firearm. There were two incidents that he was involved in. The first was ICE officers and the second was Border Patrol, and he had a license to carry. You have to understand, under Minnesota law, they're pretty strict about this. If you want to obtain a license to carry a weapon, a concealed weapon, you have to take an approved firearms course with an approved instructor, and the instructor must sign off. And as part of the course that you take, you have to be aware of the fact that if you have a permit to carry a weapon, a concealed weapon, you have an absolute duty. The weapon's concealed. It's not readily apparent to anyone, particularly officers of a court. You have an absolute duty if you are in a situation where there is law enforcement. You have an absolute duty to inform them that you have a concealed permit to carry a weapon. Otherwise, the law enforcement doesn't know that, and if they see you have a weapon, things can go sideways. And it appears that the individual in both instances, separated by 2 weeks, a week apart, he didn't inform law enforcement that he had a concealed weapon. This is negligence. So, just want to make this absolutely clear. Anyone in any state that has a permit to carry a concealed weapon, they have a higher duty than the general public that doesn't have concealed weapons to inform law enforcement that they have a weapon, particularly if they're in and around law enforcement. Second thing I want to talk about is the church invasion. And it was an invasion. So what happened after the church invasion was that a grand jury in St. Paul, Minnesota, the church was in St. Paul, not Minneapolis, that a grand jury handed down numerous indictments. I believe now it's up to 11 or 12 individuals under federal law, and numerous charges have been made against them. I went over in the previous podcast. It's federal law. It's going to be in federal court in St. Paul, Minnesota. And I also discussed previously the fact that there were numerous children involved in the church that was disrupted. It is my belief that the agitators, I'm not even going to call them demonstrators, because you have no right to invade a church or any house of worship in progress with a service for political reasons. You're not covered by the Constitution, any amendment, let alone the First Amendment. I believe they mistakenly believed that they were simply going to be trespassers, and the locals, the St. Paul police, would arrest them and just simply, let them go, and no big deal. They did not anticipate that there would be federal charges. This is stupidity. People do stupid things and regret it. They've been charged again with 3 separate indictments, and they also violated the free exercise clause of the First Amendment, which guarantees everyone the right to worship religion. It's free exercise. and not be disturbed. Now they're in the federal system. They're not going to be in the state system. Once you're in this federal system, maybe 1 to 5% get off. Otherwise, the remainder, they're going to plead guilty, or they're going to be found guilty in a jury trial. The federal government has vast resources to prosecute cases. That's why they win so many cases. Also, the jury pool will be different. If it was a local case in St. Paul, it would be a local jury made up of people from St. Paul, Minnesota. But if it's in federal court, the jury pool is taken from the entire state of Minnesota. And many areas of Minnesota are different from St. Paul. And let's just say that people might be somewhat more conservative in their viewpoints. Plus, we know that there is going to be more defendants in the case, and there's going to be more indictments, more charges found against them. Now, if they plead guilty or found guilty, then they get handed over to the Federal Bureau of Prisons. And it's up to the Federal Bureau of Prisons to place them. And they can place them anywhere they want. They can send them to dormitory-like institutions, or they can send them to a supermax. A supermax is where you 23 hours of solitary confinement, and they let you out for an hour exercise. This is not appealable. If you get sent to a certain prison, you don't like the prison, it's not like you can go to court and say, Judge, I don't like the prison. So, we shall see what happens. Just thought I would clarify certain things. Now I want to switch gears and talk about various subjects that will affect the next election, issues that have come up, and litigation that is before the Supreme Court, or will be before the Supreme Court to decide, to clarify election law. The first situation involves a Mississippi case, and the Supreme Court has agreed to hear the case. This involves the situation of receiving absentee ballots after Election Day. Most of the states, 37 states, require that the state receive absentee ballots either before Election Day or on Election Day. Whereas 13 states say that the state can receive them way after the election. For example, in terms of days after the election, Alaska, 10 days. California, 7 days after. Illinois, 14 days after. Maryland, 10 days after. Mississippi, 5 days after. Nevada, 4 days after. New Jersey, 6 days after. New York, 7 days after. Ohio, 4 days after. Oregon, 7 days after. Texas, 1 day. Virginia, 3 days, and West Virginia, 5 days. Kansas had similar law, but they just changed it and said that you have to have, the absentee ballots have to be in Election Day. And I am fairly certain that the Supreme Court is going to rule that all absentee ballots have to be in on or before Election Day. And why do I say this? I say this because there is a case involving the state of Mississippi. And what do we say, Mississippi? And Mississippi they can get them 5 days later. So there was a case decided at the circuit court level, United States Court of Appeals for the Fifth Circuit. was decided October 25th, 2024, where the Republican National Committee sued the state of Mississippi. And there was a 3-judge panel, and they decided that Mississippi should receive all absentee ballots on or before Election Day. And let me just go through the decision, because it's very interesting. And I'll be quoting some of it. Quoting, Congress statutorily designated a singular day for the election of members of Congress and the appointment of presidential electors. Precedent and historical practice confirm that this day for the election is the day by which ballots must be both cast by voters and received by state officials. Because Mississippi's statute allows ballot receipt up to 5 days after the federal election, it is preempted by federal law. 2 constitutional provisions are relevant to this case. First, the Electors Clause provides the Congress may determine the time of choosing the electors for president. So Congress intervened in 1854, fixing a uniform time for appointing presidential electors on the Tuesday after the first Monday in November. That's when we hold the election. The second relevant constitutional provision is in the Elections Clause. It provides time, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. So states decide. However, the Congress may at any time by law make or alter such regulations. That's in the United States Constitution, Article 1, Section 4. Clause 1. The Election Clause imposes a duty upon states to hold elections for federal officers. It also vests power in Congress to alter those state regulations or supplant them altogether. Let me just stop for a second. So we have elections for federal officers, and then we have elections for state and local. Generally, the states handle the elections for federal officials. However, the federal government can intervene at any time and determine changes for the election of federal officials. Very important. Quoting again, during the COVID-19 pandemic, Mississippi amended its election laws to accept absentee ballots postmarked on or before the date of the election and received by the registrar no more than 5 business days after the election. Now, after the pandemic, Mississippi has preserved that deadline and amended the statute to cover absentee ballots transmitted by common carriers in addition to the United States Postal Service. Mississippi, along with 12 other states. And the system is not uniform now. We have 13 states. We have 13 states that let the receipt of absentee ballots come in after the election, when there are 37 states require them to come in on or before, but no later than Election Day. Quoting, Congress retains the power under the Elections Clause to override state regulations by establishing uniform rules for federal elections, binding on the states. When Congress exercises that power, any regulations that may necessarily supersede inconsistent regulations of the state, given its paramount constitutional authority in this area. Federal law is supreme over state and local law. Covered this before in previous podcasts. Some people don't understand that. This is not to say all ballots must be counted on Election Day. Even if the ballots have not been counted, the result is fixed when all the ballots are received and proverbial ballot box is closed. The selections are done and final. By contrast, while election officials are still receiving ballots, the election is ongoing. The result is not yet fixed because live ballots are still being received. Although a single voter has made his final selection upon marking his ballot, the entire polity must do so for the overall election to conclude. So the election concludes when the final ballots are received and the electorate, not the individual selector, has chosen. The state like Illinois basically the election for president, they can get the ballot 14 days later, so the election's not over yet. It should be over. Back in the day, the election, the first Tuesday or the first Monday in November, that election was decided then, not 2 weeks later. Quoting, this is very important. Most people don't know this. Finally, mail-in ballots are less final than Mississippi claims. The Postal Service permits senders to recall mail with the exception of overseas ballots. So you can send in your absentee ballot and then you can tell the post office, I changed my mind, send it back to me, I'm going to change. People don't understand this. This indicates that at least domestic ballots are not cast when mailed, and voters can change their votes after Election Day. This further undermines the state's claim that ballots are final when mailed. I'm sure 99.9% of people don't know that you can call about your absentee ballot from the post office. Quoting, in short, counting ballots is one of the various post-election administrative actions that can and do occur after Election Day. Receipt of the last ballot, by contrast, constitutes consummation of the election, and it must occur on Election Day. Again, this is the Circuit Court decision right under the Supreme Court. Quoting, history confirms that elections include both ballot casting and ballot receipts. It teaches this historical practice is particularly pertinent when it comes to the elections and elections clauses. For over a century after Congress established a uniform federal election day, states understood those statutes to mean what they say, that ballots must be received no later than the first Tuesday after the first Monday in November. Why all of a sudden did 13 states change? Actually, it was 14, but Kansas got religion. Quoting, as Justice Kavanaugh recently emphasized, to state the obvious, a state cannot conduct an election without deadlines. A deadline is not unconstitutional merely because of voters' own failures to take timely steps to ensure their franchise. Reasonable regulation of elections does require voters to act in a timely fashion if they wish to express their views in the voting booth. Federal law requires voters to take timely steps to vote by Election Day, and federal law does not permit the state of Mississippi to extend the period for voting by 1 day, 5 days, or 100 days. The state's contrary to law is preempted. So it's clear to me, I'm almost certain as an attorney, well, nothing's ever certain in the law, but pretty much so, I think the Supreme Court is going to not only say Mississippi has to count and receive all ballots by Election Day, and the other 12 states, they can't be receiving them 1 day, 5 days, 10 days, 100 days later, then the election's not over. Supreme Court will be hearing arguments on this case and will be deciding this case before June 30th. Let me move on to another area of elections. What is called the SAVE Act, which has passed the House of Representatives, which requires proof of citizenship to register in federal elections. So we're talking simply about new voters. We're not talking about old voters. And we're only talking about the SAVE Act only applies in federal elections. That's the President, the House of Representatives, and the Senate. It also requires, the SAVE Act requires to remove non-citizens from the voting rolls. Some people have said, well, there's hardly any non-citizens that are voting. Others say, who knows how many. We do have something called the motor voter law, where when you go to register your motor vehicle, they give you a form to register to vote. I taught a number of foreign students, and they uniformly told me that they were non-citizens, they were here legally, and they were told go ahead and register anyway. I mean, they didn't even ask them their citizenship status. They just said, fill it out and you can vote. And then we got the whole issue of, clearing the rolls of dead people. This also requires photo ID to vote for everyone. And I'll get back to that shortly. Now, this passed the House of Representatives February 11th by a vote of 218 to 213. All Republicans voted in favor, and with one Democrat also voting in favor. I don't know why. I can come up with theories why all the Democrats voted against it. Pew Research Organization, which does research, and I wouldn't characterize them as a Republican organization. I do not believe they are. And their recent poll indicates that 83% of people that vote favor photo ID to vote. This includes 71% of Democrats, 76% of African Americans. The argument that is made by various members of the Democratic Party, I won't mention their names, stupid arguments, that requiring voter ID discriminates against women and minorities, with the understanding here that somehow women who change their name can't figure out how to clarify their maiden name and their married name to vote. Somehow they can't figure it out. And that minorities that this is racist. Somehow minorities can't get photo ID. But we've never had a situation, in my mind, other than voting, where anyone as a minority has claimed they can't get a photo ID for anything else. Like getting on an airplane, or getting a driver's license, or getting a passport, or going to the doctor. You go to the doctor. You go to the doctor or the hospital, oftentimes they want photo ID. Or you go to buy certain medications, they want photo ID. Yeah, I had to get a certain medication, they want a photo ID. I mean, I could go on and on and on and on, all the various things that require photo ID, and it's endless. So look, here's the scenario. If you think that getting photo ID to vote is racist, then we should do away with all photo ID for everything. Because if it's racist for one thing, then it's racist for everything. When in fact, it's not racist for anything. I mean, think about that. It's either going to be all or nothing. You can't say, well, photo ID for voting, that somehow that's racist. Again, this only applied, the proof of citizenship would only apply to new voters. And photo ID, let me move on to photo ID. Maybe if you can't get a photo ID to vote, maybe you shouldn't vote. And seriously, a third of the population does not vote in major elections. They just don't vote. 33%. Sometimes a little less, sometimes a little bit more. Maybe they don't want to get photo ID. They're probably not interested. We call them just non-interested non-voters. So, again, if requiring photo ID is somehow racist, Jim Crow 2.0, I have no idea what 2.0 means. If it's Jim Crow, nobody knows what Jim Crow is anyway. I won't even mention the guy's name in Congress with Jim Crow 2.0. Now, nobody knows Jim Crow or nobody knows 2.0. I don't know what 2.0 is. And I'm a smart person. I'm laughing. The anti-argument to photo ID is so absurd and so ridiculous. that it's almost impossible to believe. Now let me go through. 2.0 means 2 times? I don't know. Let me go through the status of the ID identification to vote. So we have 52 states. Last time I looked. Photo ID, 26 states require it. 12 states require ID to vote, but not necessarily photo ID. So that brings us up to 38 states. That means there's 12 states you can just roll in and vote. Vote early and often, as they used to say. So what are the states? California, Illinois, Maine, Maryland, Massachusetts, Minnesota. Minnesota's strange. If you're a valid voter, you can vouch for numerous other people and say they're valid voters too. That's crazy. Nevada, New Jersey, New Mexico, New York, Oregon, and Vermont. All Democratic states. Coincidence? It's interesting in the most recent election, right prior to that, the states of Georgia and North Carolina passed a law requiring photo ID to vote. And what they found out, based upon the previous election, that requiring photo ID to vote, more people voted. Of all groups, including minorities. Somehow they figured out how to get a photo ID in Georgia and North Carolina. Now I want to move on to the gerrymander case that's before the United States Supreme Court. What is gerrymandering? Gerrymandering is to create a voting district in a crazy shape so that it will benefit one political party. And the situation, the cases before the situation in Louisiana, but it's going to affect probably Alabama, it may affect New York State, and it may affect what's called the Voting Rights Act of 1965. There's an argument being made that back in 1965 that there was racial discrimination that discriminated against black voters, and the gerrymandering has somehow reduced the number of African Americans that voted. Well, that was back in 1965. Now it's 2026. And there's no evidence whatsoever, I'm not aware of it, that there's any racial discrimination in voting. And the court is going to have to rule that any objection to gerrymandering, you can't use any kind of racial argument anymore. They're probably going to reduce the importance of the Voting Rights Act regarding racial gerrymandering. They're probably going to say it doesn't exist anymore. The court has actually held oral arguments on the situation, and it appears that they're going to strike down important parts of the Voting Rights Act of 1965. So, in conclusion, we'll have to see how they rule on gerrymandering. They'll probably rule sometime between now and June the 30th. Okay, so I just want to give you some information as to what you're watching. Conversations with Dr. S. the Legend. And I can be reached at this email. And those of you that are admiring the beautiful Western rodeo and cowboy paintings, these can be all viewed at this website. Aren't they beautiful? all available for purchase. Dr. S. The Legend signing off.